A very good morning to everyone and welcome to the ODPP Café. My name is Anita Onuko. I'm your host for today. This is a show that is brought to you by the Office of the Director of Public Prosecution, and it's a show that is meant to inform and educate and just show you how to apply the law as it applies to the criminal justice system. We are live on Facebook, as you can see. We are also on Twitter at ODPP_KE. We are on YouTube. The address is the page is the Office of the Director of Public Prosecution. The Office of the Director of Prosecution. You can subscribe and just follow us on the channels. We are available to respond to your questions. There are a team of experts also on standby to just respond to your question with regards to today's topic, or if you have any other question that you may want responded to, there's a team of experts. And of course, today I have a panel of experts, and we're going to discuss the topic that has been under discussion on social media, which is the fight against corruption. And we're going to give an overview of what the ODPP is doing in this very important fight. As usual, I'm going to take you through a quick sneak in the courts this week. And of course, before I go to the courts, I'm going to start with the happenings at the ODPP. Last week, we reported about the court filing system, and the process is still ongoing. The Wadilifu case management system, we talked about this a while back, one of the earlier shows we had about case management system. And there was a meeting in Naivasha where in the counties where there was a meeting about the Wadilifu case system, because this system is meant to make life easy for those who are working in the criminal justice system. There was a meeting there, and lawyers were assigned to the case. Their opponents, they did a mock session of how the Wadilifu case management system works, and this happened in Naivasha. This is very important, as we discussed the time we discussed case management system, because it reduces the amount of time spent in filing court cases and how the process begins. And we also call this the prosecutor's diary. It also helps with knowing dates, court dates, and very important issues like that. So in the courts this week, two people were charged with fraud. One of them was a lawyer, Philemon Apiemi. She was charged with a tycoon for allegedly defrauding heirs of a deceased couple of their business valued of 100 million. Quite a huge amount of money. So Apiemi was charged alongside Choidram, where they purported to be director and external lawyer for Global Apparels Kenya Limited, and they conspired to defraud Suresh and Narain, both of whom are deceased, shares in the company. So this was worth 100 million. Apiemi denied 7 counts and preferred against him, but Choidram failed to show up in court to take a plea on the 13 counts he's facing due to illness. So Apiemi was freed on a cash bail of 500,000 until May 12, 2021, when they will return to court for further directions. We spoke about bail for a while. Even last week we talked about it, and when we even had bail as a discussion here, you saw how it works. So he's not freed totally, but they have to still come back and respond to this to answer to these charges. The next case we have is about the former Kenya Sevens player, a rugby player, Alex Olaba. He's held in industrial area remand awaiting ruling on whether his bail will be cancelled. Again, I like bringing this up. We talked about the conditions for bail, that in as much as it is a constitutional right, but there are some certain conditions that have to be met by the accused. Again, bail is set up on trust. So the court must determine whether you are trustworthy enough to be given the bail or bond, or even if some other conditions are like, will you be safe when you go out? Are your victims protected when you are released on bail? So a few things must be looked at. So he's in remand awaiting to see whether his bail will be cancelled. He's facing charges of gang rape jointly with Frank Wanyama, and was arrested about a fortnight ago of allegations that he threatened to kill a key witness in the rape case. You see such things happen, and one of those conditions that may cause your bail to be cancelled. So the prosecution through Evelyn Onunga said the police had concluded the investigations and are ready to charge him with conspiracy to murder and conspiracy to defeat justice. You met Evelyn Onunga here again discussing, I think, about the case management system, if I remember very well. So the court will give a ruling on the application on May 10th. So Olaba was out, and then he went and threatened the witness, and so he's back now waiting to see whether his bail will be cancelled. The next case that was in the courts this week was about a fake gold scandal. A Nigerian national was charged with defrauding an Italian of $185,000 in a fake gold trade, quite a lot of money. So Gideon Nuka was charged alongside a Kenyan Seth Okute for allegedly defrauding Lewis Ikena of the money on diverse dates between 1st of January and 30th of April 2021 through the pretext that they would export 2,000 kgs of gold for him. So they were released on 600,000 bail with a similar surety or an alternative bond. All these things we discussed about. Remember the surety, the bond, and the bail discussion. And Nuka was ordered to surrender his passport. Again, dual nationality complicates the bail or makes it one of those things that are looked at when you're given bail to the court. And then he was directed to avail 2 Kenyan sureties to sign for his release. Surety is this person who knows you in and out. And like we said last time and joked about it, surety ni mbogi yako, mtu anakujua in and out and can respond to questions about you, very personal questions about you. This case will be mentioned on May 20th, 2021. The next case is about 2 businessmen arraigned over 14 million fake money. 2 businessmen were charged with possession of 14 million in fake money. Samuel Wakaba and Boniface Mwaura were charged with possessing 68,000 pieces of paper resembling US dollars in 100 denominations, 4,900 pieces of paper resembling euros, and 6,400 resembling Kenyan notes in 1,000 denomination. The prosecution also charged the duo with 4 counts of forgery, where they were accused of forging 2 Equity Bank Lavington branch stamps, 3 United Nations stamps, and 2 County Government of Kitui stamps. Of course, they denied and were released on 1 million bond. The last case I believe I have today in the court roundups is about a man charged with raping a university student. The man is alleged to have been luring university students to his house in South Sea Estate in Nairobi and raping them. He was charged in a Kibera law court. Abdirazak Abdullah is accused of raping a 22-year-old Daystar student, university student at his home on January 14th. So this case is still ongoing. And of course, we'll see how it goes. We'll tell you how it goes in the next week or the next time it comes up. So that is as far as the courts were and what has been happening at ODPP this week. So we want to get straight into our discussion today. And this week, we have been talking a lot about anti-corruption and the fight against corruption, the fight against graft. It comes in very different terms. It's graft, it's corruption, but it's the same thing. So it's not a new phenomenon in Kenya. The prevalence of this vice and the frequency of how it's being propagated seems to have increased, and especially in public procurement, where sometimes we feel as though it is the norm. So corruption is serious. It impedes national development. It makes it impossible for the government to provide services to our people, to the citizens. And the ripple effect is really big. Poor service delivery, waste of economic resources. And of course, the worst is that it undermines the trust we as citizens have in government. So the ODPP is just an actor, one of the actors in the criminal justice system that has made corruption a focus. And that is what you are going to discuss today. The office has identified corruption as a key strategic focus. So there are so many actors, and we're going to discuss about them just today. And we're going to see what the ODPP has been doing about graft. And before we start, I am going to introduce my panel, and I'm going to give them a chance to introduce themselves and tell us who they are and what they do at the ODPP. And of course, then we can start the discussion. Karibu sana, ladies. Today is a ladies-only panel. Karibu, Madam Emily, I want to start with you. Kindly introduce yourself.
Okay. Good morning, viewers. My name is Emily Kamau. I'm a Deputy Director in the Office of the Director of Public Prosecution. Yes. I head the Economic, International and Organized Crime, where the Division of Anti-Corruption is based.
Good. So today we are just going to discuss about anti-corruption, and we are glad you're here. We are honored to have you in our panel today.
Thank you.
Yes. Karibu, Terry.
Thank you, Anita.
Yes.
Good morning, viewers. My name is Terry Kahoro. I am a Principal Prosecution Counsel with the Office of the DPP. I am in the Anti-Corruption Department and also the Proceeds of Crime Recovery Unit.
Oh, good.
Thank you.
Karibu sana. We are happy to have you in the panel. As you've heard me say, corruption is quite a topic in this country, quite a topic in the world. And I think in Africa, it's one of those topics. It informs our elections. A lot of election promises come on the corruption card. You're going to end corruption. You're going to stop corruption. But there's something you're doing as ODPP, and that is what you want to discuss today. So I'm going to start with the annual report that was released last year. It is a consolidated report for the financial years of 2017, 2018, 2018, 2019, and 2019, 2020. And I just go to an overview about corruption. Like we said, the ODPP has made it quite a focus. One of the strategic focuses is to fight corruption. And I'm just going to start with this, Madam Emily. So in 2018, cases that with convictions were at 37.4%. Then in 2019, we had 43.7% cases with conviction. And in 2020 and the first half, because of course COVID happened, but this report came up until 30th June 2020, cases with convictions were 60%. So we moved from 37.4, went to 43.7, and now at 60%. So the one question I may start with, are we making progress? What is the status of corruption?
Okay, thank you, Anita.
Yeah.
I may start by telling the viewers that the mandate of the ODPP in the fight against corruption is to prosecute. This is drawn from the constitutional mandate of the Office of the DPP under Article 157 of the Constitution, where the DPP has powers to institute, undertake, proceed, and even withdraw any criminal charges against any person in court other than court-martial. The DPP, again, can engage other agencies in matters related to crime, advise government ministries, as well as also the deal with interagency corroboration. Yes, I would say that we are moving on very well. We had quite a number of cases in court in that period, that is between 2018 to, let's say, up to 2020 December. We have so far 14 cases related to governors and ex-governors. We have 7 cabinet secretaries and former ministers. We have directors of government institutions and CEOs, 24. We have 9 MPs and 5 MCAs and other senior officers in government. As we continued prosecuting and doing very well, we were slowed down by COVID-19, like any other agency or any other department within the government or private. As you know, some of the cases involved quite a number of people, and the court space was not sufficient to give us the space
MOH
protocols.
Yeah.
Again, as we continued, even with lesser numbers, a number of our people also got infected with COVID-19, and it's unfortunate. Early this year, we lost one of our senior officers. So let's say our work has been slowed down. However, we are doing what we can do on the hearings online. This is mainly the applications in the High Court. As you know very well, the corruption and economic crimes, major cases generate a lot of applications which go to the High Court, to the Court of Appeal, and even to the Supreme Court. But we've been able to deal with those applications and even appeals to conclusion, because those ones we can easily do online. However, the actual hearings where we have to call witnesses and where we have to deal with the heavy documentation, it's unfortunate we've not been able to proceed. However, in smaller cases like bribery of small amounts, we've been able to proceed very well and even do the cases online, because not so much documentation is involved. And some have even come to conclusion. I can also say that within the office, we are doing a lot of preparatory work, because those ones council can do at their respective desk. So maybe when the
preparatory means what?
Preparatory means you receive the file from the investigative agencies. you study the files, you hold meetings, you see what you can find in court, that you make the decision to charge, you communicate to the investigative agencies, then at the opportune time, probably when the COVID is not, so after we move from that wave, we will move to court. Thank you.
Okay. So when you talk about applications at the High Court and up to the Supreme Court, this doesn't apply to the smaller bribery cases?
Well, they may apply. They can apply to any court, to any case. However, we've noted that the trend is those people, the senior people or the wealthy people who are charged with corruption cases, have the money to hire lawyers and also to file those cases from one court to another. For instance, we have one major case. I won't give the names, but it involves a governor, where we have, out of 3 cases in court, we have 14 applications in the High Court in different parts of the country seeking to stop, to prohibit the proceeding
from going on.
Yes,
wow.
And 14 in the High Court and 1 in the Court of Appeal. So
and it is within their right to do so.
Oh yes, it's within their right.
Wow.
So the prosecutors are kept very busy answering, preparing the response to the cases, and also attending to courts, online court, the
court.
virtual court. Yes.
Okay, that's very interesting. I don't think we've thought about that when we complain about corruption, that the small fish that we keep saying are targeted and the cases are concluded fast really don't go making those many applications. Sometimes they are easily concluded because of the process it takes.
Yes.
Yeah. So, Terry, we talk about corruption and they are different. It manifests differently, right?
Yes.
But then what is corruption? How do you define corruption?
Now, Anita, corruption is a terminology that has for a long time been defined, both internationally and even within our laws. But really, it is simple because corruption is manifested in a very simple way. One, it is an offense of deception, where a person who, again, is in charge of public funds or management of funds engages in deceit, either alone for his own benefit or to benefit another person. And the motivation is only one, Anita. That is why, for me, corruption is a very simple offense. It is illicit gain of money. So if you look at the definition, you are able to pick out 3 terminologies. One, the personality. Somebody who is in charge, somebody who is able to either do an action or not do an action, so that money that is supposed to be for public use or social use is put in the hands of individuals, be it himself or to a person he wants the money to go to. And I heard you talk of mbogi. Corruption is actually done, if you look at it, it is a secretive offense, where people want to do it in a covert manner. And that's why sometimes you find that it is an offense, as much as it is rampant, it is also a very hidden offense, because people are stealing these monies discreetly. And that, to me, that is what corruption is. And that is what where ODPP and other agencies come in to try and now reveal, unveil, and bring justice to the public through prosecution of people engaging in this offense.
Yeah. So Terry, there are those in office who do this, who propagate corruption. But again, there's the person who we know there are things that we have to pay for, services that we have to pay for, so that we get served, so to speak. So then there's the person in the office, and there's the person who comes to the office and pays for this service. So does the ODP also deal with this person who walks into?
Absolutely. Yeah. And the term for that is conspiracy. The person in the office and this person coming in, they have to conspire so that they complete that offense of corruption. So there are many offenses that can be described as corruption. I will just give you a few examples. One, abuse of office. So that is a person you are saying is in charge, maybe of a government agency. He could be a cabinet secretary, somebody who is in power and in charge of the finances. Then you have an offense of conspiracy, which I've mentioned, where now the 2 people come in if the person wanting services is able to give a kickback. So again, you see the offense of bribery, where this person coming in bribes and the officer fails to do something or does an action that is not proper. We have acquisition of public properties. So you see in the end result, somebody gets a public property that is illicitly.
Yes.
Could it be money? Is it a service, a tender, land? So those are some of the major offenses that are manifested in corruption.
So, Madam Emily, with all the laws we have
Yes.
that are meant to stop corruption, does it help? Do they help? I mean, in the fight against corruption, are they helping in making this progress we say we are making?
Yes, I would say that we have quite some good laws meant to fight corruption. We have the Corruption and Economic Crimes Act 2003. We also have the POCAMLA, that is Proceed of Crime and Anti-Money Laundering. We also have good offenses in the Penal Code. The Penal Code, although old, also have the offense of abuse of office. It also have obtaining by false pretenses and stealing. It also have, let me say, forgery. Although forgery in itself, it's not a corruption offense per se, but a lot of corruption is done through forgery.
Through forgery,
Yes, through forgery. So we put them together when we are charging. That is the Corruption and Economic Crimes Act, and then also the Penal Code. And then when we get that there were proceeds from that crime offense, and it can be traced, then comes in the POCAMLA, the Proceeds of Crime and Anti-Money Laundering.
Okay.
Yes,
So
and we have filed a number of cases whereby the three acts are put together. We call it the Anti-Corruption and Economic Crimes Act, yes, the Penal Code, and the Proceeds of Crime.
Yeah. So despite us being a very religious country, despite us having all these laws, corruption is still an issue that we have to fight. So the other question I have is, because it still happens, how do you arrive at the decision to charge corruption cases? Is it the same as all other cases? How do you arrive at it?
Okay. Yeah. Thank you, Anita. Yes, we are very religious.
But yet we engage in deceit.
And also we have all the religions, Christian, Muslim, Hindu, and all that. But I would want to say one thing, and we've seen other countries what they do. You don't wait until corruption happens. Prevention is very, very key. And I believe Kenya is not doing enough to prevent corruption. From what I've learned over the years, when an opportunity arises, anybody, however religious they are, they'll partake.
They'll fall.
Yes. They'll fall. Mm-hmm. So unless you cross the stables, definitely the horse will halt. For instance, for a long, long time, we used to have cash transaction. You would pay the court fines and everything. You would pay in cash. So that opened a room for corruption. Everywhere one was going for services, they were paying in cash. Yes. It's just the other day that we were launching the registry, the land registry to be digital. Yeah. But we had so many people going to the land registry. Of course, that was we call them wet areas for corruption. Okay. And then the interface, when you get those offering the services and those who are giving the services coming together, definitely corruption will occur. Yeah. So one of the things that we need to do is to work quite a lot on prevention, so that not so many incidents of corruption happen. Yes. Even the procurement cases, if we move out from dealing with those people who we are contracting, the interface, so that you don't even get to know them, then we will ease corruption.
Are we making progress there in public procurement especially? Because I think it is one of those that is making you very busy. Yes, in prevention.
Yes, like you say, it's a difficult area, but I would say we are making progress. First and foremost, we now have a new law. the Public Procurement and Asset Disposal Act 2016. So the law was reviewed from what we had in 2005. So the gaps that were identified in 2005 were breached in the 2016 version. In the 2005 version, we realized that the process was so long. And that again brings in corruption, because everybody wants like somehow to bypass some of the processes.
Yes.
And then again, you give room to a number of officers, from the one who starts at point A up to the last person. So in between, corruption will come
happens,
in.
yeah.
So as we see the areas that are bringing in corruption, we try to break them by maybe shortening the processes. And that's why we are saying, like, even when you have, let's say, like the passports, the acquisition of passports or birth certificates, and we've had so many people crying out there that they had to pay. If digitizing them, having to apply them online, also cuts a lot of corruption.
The middlemen.
Yes, the middlemen. And even the frustration of the person who is seeking that document makes that person go seeking. Is there a person I can talk to and give them some money so that I don't have to
It's our
make this
Kenyan
long
lingo.
queue?
Najua mtu. I know
So
a guy
there
who
are
knows a
some
guy.
very simple things you can do, and you cut out a lot of corruption.
Yeah. So how do you make the decision to charge in corruption cases? We discussed this last week as being the most important decision a prosecutor makes. Corruption is a big deal. The minute you charge someone with corruption, then of course there's something hanging over them until they are cleared. So how do you make the decision to charge?
Okay, the decision to charge in corruption and economic crime cases is made just like the other cases.
Yes.
First of all, the DPP does not investigate. The investigations are undertaken by the investigative agencies. For corruption, mainly, we have the Ethics and Anti-Corruption Commission, who investigates several corruption cases under the Anti-Corruption and Economic Crimes Act. The acts enjoins them, once they finalize an investigation, they have to submit the file to the DPP. Let me just go back a bit. There are the major cases. We have what is called prosecution guided investigation, whereby even before the file comes to the DPP can appoint, through requests, or the DPP can offer to send some officers to assist the investigative agencies, not to investigate, but to assist in the technical, in the legal areas, in the course of investigation. However, we do not go to the ground to investigate. Once the file now comes to the DPP now independently makes the decision, and that decision is guided by the sufficiency of evidence. That is number one. The evidence must be sufficient before you even come to the other test. That is the public interest test. Sufficiency of evidence is key. Then once the DPP is satisfied that there is sufficient evidence, moves to the second stage of public interest. Is it in public interest to prosecute? Public interest does not mean that the public was the person prosecuted. It must be, is it in the good of the public to prosecute this case? Then the DPP proceeds and gives the consent to charge, and the investigative agency, it could be the DCI, that is the Director of Criminal Investigations, who also investigates some corruption cases, and the EACC then are allowed to arrest and arraign those people to court. Then the DPP prosecutes
the case. It's very interesting you bring up the public interest aspect. We discussed it again last week when you were discussing the decision to charge, and we wonder, I asked from, of course, from a layman's perspective, if it is what is interesting to the public. But then you must agree that all corruption cases, if not all actually, should be both of public interest and interesting to the public, right? But then can the public inform how you go about your cases? Can you go on Twitter, make so much noise because of the corruption, say in public procurement, and then it spurs you to action? Like, oh, people are complaining, letters.
Well, even if members of public are complaining, yes, we understand. On the other hand, we are also members of public. We also are affected when corruption happens. However, we must be professional. and we are also accountable. The Constitution tells the DPP that he must take into account public interest and the interest of administration of justice and the need to prevent abuse of the court processes.
Yes.
Because you cannot just go to court and file a case because the public out there is paying for,
for blood.
somebody's blood, and you don't have the evidence, evidence to table before the court. Remember, the DPP can also be sued for malicious prosecution.
Yes.
And we've had, we've seen many cases, not recently, some cases which happened, probably some of them in the 90s or 80s, where the government is paying a lot of money for cases they took to court and they did not have sufficient evidence. So we must guard against that.
Oh, that's good to know. So Terry, the criminal justice system, there's a way it works even in anti-corruption, and Madam has taken us a bit about what the ODPP does.
Yes.
Who are these other actors that complete the system?
Okay, now the system is a chain that starts from a point where a complaint is launched, be it by an individual, anonymous, or whoever reports. So the first agency that takes up its mandate are the investigators. So we have the DCI, the Director of Criminal Investigations. We have the EACC, the Ethics and Anti-Corruption Commission, whose mandate is now very specific to anti-corruption matters. We also have other agencies that can deal with investigations, KRA, who are specialized in tax matters. And also we have institutions that deal with police complaints, IPOA. So we do have the investigating agencies who carry the investigations. And once they also are satisfied that they have collected enough evidence to which should be specific to a crime that they have identified. Is it a case of abuse? Is it a case of deceiving principle? Is it a case of fraudulent acquisition, willful failure, all the offenses that we discussed? Once they have completed the investigations, they now forward the file to the ODPP. So the ODPP comes in now as a prosecution agent. We also have others like ARA, especially in a case of corruption and proceeds of crime. We work very closely.
With ARA?
Oh, the Asset Recovery Agency, which is tasked to actually, you know, Anita, the criminal justice system has moved from just going and taking people to court. We are now going to following the money. So the prosecution and ARA and DCI work very hand in hand to make sure that the person does not benefit from the illicit funds. Then, of course, we have other...
Because, sorry, Terry, there's that conception or the story that atashikwa, aende amalize time, arudi aendelee kuenjoy na the generations and generations will benefit from this money. So have you made any progress in the follow the money approach?
Indeed, we have made a lot of progress. And I would say this is one strategic plan that is effective and that will actually change the narrative of corruption cases. Because like we discussed, corruption, there's only one motive: illicit wealth gain. So if you leave the illicit property, that person, like you say, will go to jail or pay a very simple fine and go back and enjoy. So we are saying we must follow what they took. So I can say we are doing it in different fronts. I can give a few examples. One being that we are now enforcing Section 48 of ASECA, which has been there, but...
ASECA?
Yes, the Anti-Corruption and Economic Crime Act, which has, the Act provides that where the prosecution can prove that there was loss or that the person benefited, you pay 2 times of the money. And a good example is the Waluke case, which I mean, it was one of the cases the DPP and the criminal justice system has celebrated, because it showed that you can actually take away that which someone benefited. Then the other front is actually going for the property. So at the beginning of the case, and this is where the complexity even of corruption cases comes in, because you have to do a step-by-step follow-up. And I'll tell you, criminals hide the properties. You will find that they don't just take the money and buy a car and register it in their name or land. They really take what we call,
They go to great lengths.
yes,
Yeah.
they launder the money. They conceive, in fact, the nature, the source, and even the ownership of these properties. So investigations into all that have to be done. Now, and going back to the agencies, so now the ARA, the Asset
Yes.
Recovery Agency, the DCI, the investigators, the EACC, and the prosecutors have to work very closely together to be able to gather all this evidence. And also we have the police department, the prisons department, and the reform departments. We have agencies that the judiciary comes in at the end.
Yes.
Once we present now the corruption case, the judiciary now comes in, and their role is also valid, from receiving the charge sheet to dealing with issues of bail and bond,
Yes.
the applications, ultimately to acquitting or convicting
Yeah.
and sentencing, and those are the players. And I think the one thing that I would say we internationally, and even Kenya is really adopting, is working together. Because if one agency fails,
You have
I
to
would say
collaborate.
everyone fails.
Yes.
So if an investigator fails, I should be very sad, because it means as a prosecutor,
You all fail.
I'm likely
the
to
system
fail.
fails.
Yes.
Yes.
So encouraging a lot of working together. That is the way we
I will
fight.
ask you a very controversial tweet that came from Lord Mutahi.
Yeah.
He claimed that a report was released that mentioned ODPP as the weakest link in the fight against corruption. So I'll just read a bit of that part. He said that they have achieved some marginal level of success, and hence rated the organs as majorly successful to a small extent. I don't know how with the least performing organ being the EACC, one of the players you've mentioned, followed by judiciaries, anti-corruption courts, and the ODPP. What do you have to say to this?
I would say that indeed he has mentioned all the players in the criminal justice.
This is everyone,
system.
right?
Yes, he mentions everyone. And I say, of course, there is, every agency has to play its part. For example, the investigator has to go out there and collect as much information as he can, and of course use that's why doing trainings to investigators, prosecutors, the judiciary is very critical, because the crime of corruption is a crime of calculation. It is not a crime of passion like many other crimes.
Yes.
A person committing a
Be
corruption.
passionate about money.
Yes, indeed, because someone has sat down by himself or in conjunction with others and calculated how to siphon money.
Yeah.
So it is a very technical offense, if
Yes.
I may say.
Yeah.
So as the criminal players in the criminal justice system, we must get to that level of expertise. We must get to the level of thinking. So I think just to answer him is that I can say that in the recent past, indeed, there has been a lot of capacity building to all the agencies, so that the investigator is able to do his work properly. The prosecutor is able to also engage his mind legally and looking at the evidence. And also the judiciary is able to look at the evidence, appreciate, and also use the law to give the appropriate sentencing that is required.
So it's important to understand the role of each player in the system.
Yes.
Yes. So maybe, Madam Emily, I'll come back to you as you talk about the criminal justice system.
Yes.
Claims of cases taking too long to complete, corruption cases. And I think there was even a letter. I mean, why are we taking too long to prosecute such cases? I don't know what you have to say about that.
Okay, thank you, Anita.
Yes.
Like my colleague Terry has just said,
Yes.
these are very complex cases. And I also see that they involve very heavy documentation. Others involve international aspects. And you cannot go to another jurisdiction to investigate without getting leave there are formalities which must be undertaken to have that matter investigated in another jurisdiction and the evidence brought to our country.
Yes.
Of course, that takes quite a bit of time. So I'm talking about the investigative stage might take a bit long.
Time.
And like what we said, the corruption activities are entered into for the gains. That is where it's money, where it's land. Now with the money and with those huge sums of money, you'll find that a lot of it goes even outside the country. So you have to follow it up to where it went. And you have to get cooperation with those other countries. So some of these major cases have got an international aspect because the money goes out. Some goes out and comes back. We have seen that, but you have to follow the trail. You asked me about
KEMSA, yes, because this was a very specific ask about KEMSA, and it speaks to the question of why cases take too long. And
okay, we know first and foremost, I would say that KEMSA is not yet in court, and not that the DPP is not interested in prosecuting, and not that the members of public are not interested in having the matter prosecuted. However, I'll remind you that we say the first test is sufficiency of evidence. We did receive some, that is the office of the DPP received some files from the investigative agency, that is the anti-corruption agency, and we studied the file thoroughly, and if you check some of the quarterly reports which are gazetted, the file was returned to EACC with a lot of areas.
So that is public information?
Yes, anti-corruption quarterly reports. Yes, it must be, if they are gazetted, because the reports are gazetted, that the file was returned for further investigation. I think the first file had covered only the procurement aspect. But you note that the members of public also are not talking about the breaches, they are talking about the money, the money that was lost. And following the money is not easy. We are not saying that we are not going to do it. What I would like to say of now, that there is a lot of work that is going on. Yes, we know we've had a lot in the media, that so-and-so took this, so many millions, so-and-so took billions, so-and-so bought this. However, unless and until that information is documented and packaged and witness giving that statement, and if it's bank statement, we get to see how that money moved from that person to all the other person, then I don't think I'm ready to go to court. Yes, I know, and we are very concerned about this matter, but we must do what the law expects us to do.
Are you part of, I mean, I think what brings out a lot of emotion is what we watch on TV, the inquiries. Are you part of that? That is just now investigating.
No, that is the parliamentary inquiry. No, however, and I think there is one report comes. What goes before the parliamentary committees? We can even say it's hearsay. Yes, because witnesses are not lined up to give evidence. They are not sworn. I'm talking about witnesses, not those people who are called in to be questioned. However, what comes out must be subjected to forensic investigation and packaged.
So does this parliamentary proceedings, are they in the criminal justice loop?
No, but they can be just like, let's say, intelligence. Just like the way you can read something in the newspaper, or you hear and tell the investigator, investigate this. You note that even the parliamentary committee that is undertaking the inquiry, in their report, they recommend to the investigative agencies to investigate. So whatever comes from the parliamentary committees or any other tribunals, or even the Auditor General, we can't take the Auditor General report and go to court with it. Whatever comes from there must be subjected to investigations. Investigation means witnesses must record statements. Whichever document they are talking about must be brought on board. If they are talking about bank statement, you must go to that bank and get those statements. If there is something to be gotten from another country, you must make an application and package them, then that one, even in the most developed countries, such
time.
cases takes quite a bit of time.
Okay.
Yes.
So it's very good to note, because we assume, I am one of those who assume, that once I see these proceedings in Parliament, then investigations are on. So the next step I want to see is, has the DPP acted? You know, I mean, amesikia yoyote, umesikia? Act now. So I think that is what pushes people to go and say the DPP maybe is not acting on these cases. But it's very good to clarify these cases. So maybe I'll ask another one, Madam. And thanks for clarifying on KEMS. I'm also
Okay,
very
thank
clear
you.
on it. Yes. There's the Kimwarer and Aror. Whenever we post, somebody must throw it and say, what happened to Kimwarer? This is all political. You are not going after, you know. So what happened to that case?
The Arrow and Kimarero Dam cases were also very complicated cases,
Yes.
and the investigation had taken quite some time. And even when the matter came to the DPP, there was shuffling between the DPP and the investigative agencies to go and investigate that, go and get that document. I think there were also some international aspect on that case.
Yes.
But finally, we managed to file the case in court, and it's ongoing. So I won't even go into the merits or demerits of what is before the court.
Yes.
However, like I said when I started, it's one of those cases which was also affected by the COVID.
By COVID.
Yes.
Yes.
So we've not really been moving. I'll, however, point out that there are two applications before the High Court seeking to prohibit the proceedings in this case.
I think we're learning this term, application. When you say there are two applications.
Petitions.
Yes, yeah.
A petition is going before the court.
So this is someone saying stop this case.
Yes.
So you
to
have how
prohibit.
many? Yeah. Two in that
yes,
case. Okay.
Probably some others will still come up.
Yes.
In such cases, we expect so that some
Yes,
accused
something else will
person
come
will
up.
go to seek
Yeah.
a higher court to have the applications.
Yeah.
Sorry, to have the charges stopped.
Okay.
Yes.
Okay, then still on these cases, because we have to talk about this, we can't just ignore them. There has been taken long. Again, it's also in the space of why a corruption case is taking long to conclude. Do you have any update on the Imperial Bank case?
Okay. Now, the Imperial Bank case, there are two. Maybe you could, which specific?
Do I know? Let me check what the question was on about.
Yes.
But I know that has come up quite a bit, and people just are seeking clarification. So Alexander Sarikas on Twitter asked, in case you remember, please look into Imperial Bank theft. It's been stagnant for 6 years down the line. I wonder why it's too hot to handle. So that's about duration. Yeah. And the other one, let me just try and get it. This one, I don't know how you get it, but then someone called Overcomer on Twitter said, it doesn't make sense that ODPP hired a Queen's Counsel to prosecute a case against the DCJ using evidence fraudulently taken from Imperial Bank, which qualified for a civil litigation, but you use police prosecutors to prosecute multi-billion corruption cases. So this guy has maybe 3 questions in one. Maybe we just deal with the one for Imperial Bank and also clarify, and we've talked about this before in the show, about police not being prosecutors. So just pick it from whichever angle. Imperial Bank.
Yes. Now, the Imperial Bank matter was a banking fraud matter. And again, complexity of the matter. This is one matter that had thousands and thousands of evidence that is also very technical. In fact, even just being able to get this evidence was, I would say, for the investigators, a nightmare. Because a lot of documentation, but this is a case that is already in court.
Yes.
I am aware that already witnesses have started testifying in the court. Now, there has been challenges. I will highlight, I think, like 2. One, the court, there was a change in the magistrates changed.
That affects cases.
It does affect cases.
Okay.
So it had to get to a new court, which can even now bring in the issue of restarting.
Oh boy.
And the witnesses are very technical. So it would take one witness days to just have his evidence recorded in court. So the nature of the case in itself is very complex. Now, the other challenge, of course, is COVID, which it is one of the matters that has been categorized as it cannot proceed for various reasons.
Yeah.
A lot accused persons are many. The counsel and also the space. So the MOH guidelines.
Guidelines must be followed.
And lastly, there has also been an application. While the matter was proceeding, you get applications. I am aware even the application is in the High Court is coming up, I think, next week. So these applications also slow down.
So these applications for you can't continue with this, so the court has to decide.
Yes.
Okay.
But there has been steady progress in terms of having the matter in court and already starting to call witnesses.
Okay.
Maybe, Anita, I could add two things which really slow us.
Yes.
Because you hear a matter is already in court, but it's taking so long.
Yes.
First, our court processes are still manual, meaning the magistrate or the judge has to write everything that is being said.
Manually?
And yes, we are still there. That is, we should do away with that.
That's a lot of work. So they don't...
And they are human, they get tired.
Yes.
Sometimes you see a witness is talking and nothing is being recorded. So that one. And then what we call in writing viva evidence. Viva is that our law requires that a witness comes and say. In other jurisdictions, they have moved from that. They can rely on just affidavit. So you can have all that evidence packaged, and you get a witness to just come file an affidavit, and maybe 2-3 witnesses. Whereas ours, if you have 10 people who talked about that document, all of them will have to come. I can give a case in point like the Chicken Gate in UK, where the UK finalized their case years back, and ours is still ongoing in court. But we realized theirs, they used very few witnesses who just filed affidavit in court and a few documents. They didn't have to, like us, the cartons and cartons of documents which you have to table before the court. So those are two things that really slow the pace. It's not the court to blame, it's not the DPP or the investigators, but
just the process.
Yes, maybe the way it was, our criminal procedure code, that requirement that the witness, a document must be produced by its maker.
Wow.
And if the maker is not producing, then you have to give the court good reason. As long as it's the law, then we still have to follow. However, we're like, I didn't say this, but we have a law reform committee, interagency, and we are looking into how we can modernize our processes.
The processes.
Yes.
Yeah, I was just wondering, and I bet somebody would ask, who decides the number of witnesses who comes, testifies in a case? Can you?
Yes, that is the prosecutor, but it can be quite tricky because there are authorities or decided cases which say failure to call a material witness will be assumed that that witness would have given evidence that is against the prosecution. So we give disclosure, whereby we are expected to disclose all the information we have in our possession against the accused person. That is through the Article 50 of the Constitution. Thus, the DPP does the disclosure, give the information, but we can choose to cut down the witnesses. However, the other side can insist that this witness be
all of them
called.
And
again, if a witness is being mentioned, you have got no choice but to bring that witness. Again, cases stall because some documents are being mentioned, they have not been served, and they insist that they have to be brought. So you as a prosecutor might want to reduce the number of witnesses, reduce the documentation, but you end up being...
It may still come back to you.
Yes.
Okay, so are there, I don't know that you talked about this, but are there any, what is it called? Are they trying to change this court process? Because I can imagine writing by hand, listening to someone and writing by hand what they're saying.
I'm aware, we've really been pushing for it, all agencies, including the judiciary officers themselves. One, it's tiring and it really slows everybody down. But it requires funds and all that. I think it's being worked on.
It's being worked on. So Terry, tell me, there's the person who's abusing office.
Yes.
But then there's Anita corruption going on. How do I report this? Do I go to the police? Do I come to ODPP? Do I go to EACC? Where do I go?
I would say the players in the criminal justice system encourage that you can report to any of them, because we will, for example, of course, the investigators, that is their mandate. But even as ODPP, we do receive complaints. Okay. In fact, and we are able to direct. It is in the law, it is in the Constitution, and it is in the ODPP Act, where the DPP can direct
an investigation.
Yes, it can be anonymous, because you see sometimes people who want to report are afraid of the consequences, because this could be their bosses, it could be the people they are close to. So I know the Ethics and Anti-Corruption Commission and even the DCI, they have open hotlines where, or even you can discreetly report an offense. At ODPP, we do the same. It will also trickle down back to the investigators, and your identity is protected. So then the avenues are there to report, because at the end of the day, we all have a responsibility. And even as the criminal justice actors do their part, Kenyans must also help us.
Help us, yes. It cannot be just done by the agencies only.
Yes.
We must work together. So I'm wondering, must you prosecute on corruption cases, or can they, because we learned about plea bargaining here, we learned about diversion. Do they apply in criminal justice system? In prosecution of corruption cases?
Yes, and I will start with what has been one of the biggest problems within the criminal justice system. It has been something we've talked about, delay,
yes,
backlog, and cases not moving. And sometimes it is because the system is clogged.
Yes.
The system is clogged with too many cases. So how do you now deal with criminal cases in a way that actually makes it justice is seen to be done? And I would say one of the strategies that is also, and like you have mentioned, we have the plea bargain, where the person, so the issue of, again, people becoming more transparent and also owning up. Because if you look at the alternative to prosecution, it is dealing with a criminal case without having to go through the whole judicial system. But it has to come also with responsibility.
Yes.
A person has to be able to admit, that, yes, because...
You plead guilty.
Yes, you admit that this and this happened. And we are seeing progress, and we are seeing changes.
Yeah.
So people are coming up more and bargaining.
Yeah.
We also have diversion. Some cases you look at the public interest, and you see it is not in the public interest to go to full hearings. So you cut down on them using the diversion.
Yeah.
And also the deferred prosecution agreements, which have been very effective with dealing with corporates.
What does that mean?
Now, the deferred prosecution agreement is just a form of diversion, where a corporate or an individual can actually again give his intention to settle the matter. And you look, of course, the prosecutor again has to make that decision to prosecute. And where the circumstances allow, you engage these institutions. They can, for example, in the case of the banks, they are able to rectify the mistakes. And also, so there are terms that are set that you must do this and this and this. And it is a very open process. It is reported. Therefore, alternatives to prosecutions are coming in very handy to declog the criminal justice system. The Constitution supports and actually encourages, and also it is a very good way of ensuring that punishment must not just come by jailing. It can also come by ways of restitution, and also making sure that everybody is in the system.
Is that being too lenient?
No, it is not.
Do you follow the money in such?
Yes. In fact, to the cause, one of the things I know when it comes to alternatives, especially in corruption cases, the person, even before you say anything else, the person must return that money. And again, remember the motivation. Yes.
Yes, we are just answering, I think, without knowing you are answering to Vivian Kambaga on YouTube. Thanks, Vivian. She asked about, is plea bargaining encouraged in corruption cases? And we said yes, right?
Yes, I did.
And then what are the benefits of the accused person in such cases?
Now, the accused person, one, he doesn't have to go through the long criminal system, the court process. So he's able to own to his mistakes and get back to life. You see, again, it's not, the criminal system is not about ending people's lives.
Yeah.
So the person is able to admit their mistake, pay the fines or the penalties, and be able to go back to their lives and to their families.
Does it hang on my head that I can
And
get a
again,
certificate?
probably I can add
Yes.
that in plea bargain, just like the word connotes, it's a bargain. So both sides must win. That if I plead guilty, I've also cut the cost of prosecution, the court's time,
Yes.
the witnesses do not have to come.
Yes.
Therefore, if you had like 5 counts, maybe you can reduce them to 3. And then the court will also take into consideration as mitigation that you pleaded guilty and you did not waste time. So if that sentence was supposed to be, let's say, 5 years, you can get 3. So everybody wins.
Yes.
Again, you can get a plea bargain. Somebody pleads guilty, and then the prosecution can say you plead guilty, and then we use you as a witness to tell the court what actually happened. You can even get somebody to plead bargain, and then maybe the sentence is reduced drastically, and then this person will help you unravel the mystery, because it's only the accused person knows exactly what happened in that scam. And we have seen that other developed countries like UK really relies on those accused persons who have plea bargained to nail the others.
Okay, I think I've read this elsewhere, and a lot of arguments that say we are too lenient, that we need to just shoot or hang people engaged in corruption. I mean, what do you tell such a person? The rule of law must be followed, right?
Yes. Any country that I believe is democratic, you cannot throw away the rule of law.
Yes.
And this means that, you see, once a case you're investigated, you are still innocent until you're proven guilty.
Yes.
So can you imagine shooting people before at least there is that is the future of dealing with criminal
corruption,
or any other offense.
Yes.
We are moving more in democratic societies towards restitution and preserving the society.
Yes.
So we do not think that is
that is the best way.
Yes. But again, stringent measures must be put in place to prevent and also to deal with the corruption cases. And I think in the recent past, we have even been accused of being very active and prosecuting.
Yes.
And that is how we have a leadership that is giving clear signals that we are intolerant to corruption. Yes.
And maybe we need to speak to this again, Madam, because the story of big fish versus small fish comes up. Why is it that we see a lot of the so-called small fish? Their cases are concluded. I know we talked about it just for clarity, because it comes up at you mnafuata to the small fish, but you don't go after the big fish. I mean, how do we?
The small fish, let's take like the examples
the
of
omenas,
the small bribery cases. The cases are not so complex. In fact, you can go to court and 3-4 witnesses are heard the same day, and probably the documents are so few, you are able to finish it even within 1 month. But the other one I've gone through, I don't think I would repeat the complexity of these matters. Where you have huge amount of money, even the documentation itself is so huge. And I said, probably, and most of the time, these monies cross the boundary. So you are talking of another jurisdiction, and you have to get cooperation from those other jurisdiction for them to agree to bring that evidence.
Okay. Terry, is the bail given to an accused in a corruption case equivalent to the amount of money being discussed at that time?
Now, the issue of bail is guided. There are factors that the court has to consider in determining the amount of bail.
Yes.
Because it is a balance between the prosecutor and also the rights of the accused persons. in corruption cases, of course, these factors may vary from one case to another. A person who is a flight risk, of course, that one is very clear.
Yes.
But just to be specific on the issue of the offense committed, you realize that you can have cases where the amount is a lot. So the court, and I think there is case law on this, the court from even other jurisdictions, India, the UK, the US, the amount that has been lost is a factor that must be considered by the court in determining the bail. Of course, there has been many applications. The prosecutors have been, in some cases, very successful where very high bail terms have been set. And the accused persons always come in to also challenge that. So I think that is a factor that must be considered, the amount. And also strike a balance of the two. Yes.
Maybe decided cases in this country have stated that bail terms should not be punitive. That is, it should not be used as a way to imprison the person before the trial ends. Cases like in 2018, we had cases where bail was set in considering the amount that is lost, and a number of people stayed in custody for months. So when they went to the High Court, the bail terms were reduced to then an extent that they could afford. Because again, bail is the security to ensure that the person will turn up for his trial, and it's not even a fine when it belongs to the government.
Does the fine, is it commensurate to the fine?
Bail? No,
not at all.
Because we've said in corruption, the fine can be twice the money lost, all the money the person gained, but the bail is not that, like that.
Okay. Thanks, Agatha on YouTube. Thanks for tuning in. Thanks, Lillian. William says, good morning. This is very informative. Happy to learn how going digital helps with the war on corruption, especially in wet areas. I think we learned that wet areas earlier on. And then thanks, Robert. Rebecca says, good morning. This is very informative. And then Karaoke is tuned in. Thank you very much. Vivian, we've answered your question. So I'm just going to pick some more questions that we had earlier on Twitter. These are not even for today. We talked about the length of the cases. We said, Martin Gare asked, how long does it take to investigate and prosecute the individuals found guilty of the offenses? And we said it's not cast on stone. It can take short or long, depending on the complexities of the case. Abdilatif Afdub says, this sounds extremely good, but practical action is required in all aspects, and hope will be a getaway for the victim looking, I think he's talking about justice being served to the victims. And I think a lot of what you do is the victims are normally the citizens, right? Because of public procurement. So he's hoping that we actually deal with, we get justice. Just a minute, I've gone off it. I just want to get to Facebook and see what people are saying, but thanks very much for following. We appreciate your comments. Why can't the ODPP encourage ADR in cases where parties are willing to settle out of court? Could this be about corruption? And what is ADR?
Yes.
There is no alternative dispute.
Okay, yes,
And we have mentioned the deferred prosecutions. So it is being encouraged, yes.
Okay. Taken 2 years to charge some KRA cases. I don't know which one specific. Are there KRA cases in court that have taken 2 years?
We have KRA cases, and like we said from the beginning, we have the process that all the cases that are submitted by the investigative agencies must go through. We have the file is submitted, the file is reviewed, if we have sufficient evidence, we charge. Yes, we have received a number of KRA cases. I don't know which one the person
they're
named.
not very specific.
Some we have already taken to court. If it's the KRA officials who are caught in connection with bribery issues, we took to court, and some of them moved to the High Court, challenging our action. And the cases were stayed. They are not. Yes, that must be what they're asking.
Okay.
That the 2 years, because I think it's around those 2 years, they were taken to court, several applications were made, and the High Court stayed, so we could not move.
What does it mean when the High Court stays?
The High Court tells the DPP pause.
Oh, okay.
Yes.
All right.
Until we determine the issues that have been brought. That may be through application for judicial review. You know, the DPP is independent, but once the DPP makes a decision, that decision can be challenged, but only through the High Court.
Okay.
So the High Court looks at the manner in which the DPP made his decision. Did he abuse the process? If the court finds that the DPP abused the process, then the court can say the proceedings are prohibited.
Okay.
And we also have probably few cases which were prohibited. So that's why you see persons who are charged moving to the High Court. So the KRA cases we charged, and there were a number of them moved to the High Court.
Yes.
And the High Court, let me use the word post for the
yeah,
for the
please say
EDP.
post, because we get
Yes,
confused. Yeah.
post.
Yeah.
Because they have not been prohibited.
Yeah.
It's like being told, stop there until we determine these issues which have been brought before us.
Okay.
Yes.
I hope you've had your answer, Betty Buleta, and thanks for following. Peace, Irene, thank you very much for following. Chuta Yusuf, we talked about ADR, and we said yes, it's encouraged. Thanks, AB Kipngeno, for following. Thanks, Donnell. And yes, thanks for following, everyone. We will still try and answer some of your questions, and maybe we can just talk more about the challenges apart from those applications. What are it against graft?
Okay, the other major challenge in corruption and economic crimes,
Yes,
I would say compromised witnesses.
compromised witnesses.
Yes, there is a difference between threatened witnesses
Yeah.
and compromised witnesses.
Yes.
Compromised witnesses are those ones who have gone to the other side. They recorded statement in telling the state or the DPP what exactly happened in that.
Yeah.
But now when it comes to the hearing of the case, you find that they are not so willing to come and testify.
Yeah.
Some understandably so, because you see the corruption most probably happened in the workplace.
Yeah.
And they're being called to testify against their seniors.
Yeah.
So some of them feel, okay, they might get compromised, or they are intimidated, and they might not even tell you, but we start witnessing these changes when the hearing starts. They will always find excuses of not coming, and they'll also, some of them, they change their story from what they recorded. They start telling the court other things. Yes, definitely, understandably so. They want to preserve their job. Supposing this boss comes back to work, then they will lose their job.
Do you have witness
protection? But remember, if you are compromised, you are the one who is willing.
Yes.
So you are not even telling the prosecutor that this other side has approached me. Why we know, because they change, and this happens quite a lot, and it's a big challenge. That they change their story, and they might do so when they are at the dock testifying. They start saying other things, or every question they asked by the defense, they say yes, and you can see it is aimed at assisting the person who is charged to get away with it. Okay. So that one is not a witness for protection. As regards threatened witnesses, and that there is the Witness Protection Agency. We work with
it is separate from ODPP.
Yes, completely separate. It's a semi-autonomous body at the Attorney General's office, but they are also independent.
Yes.
So has been threatened, then we make an application and it's considered that they are protected. However, the witness must be willing to be protected. Some might be moved or taken elsewhere, away from the accused persons, or they might be allowed to testify in a way that the accused person will not know who is testifying against them. Instances, these must start at the investigative stage, especially in the cases involving very senior personalities. We see that so-and-so is a junior person, they are coming to testify against such a senior person, so we must give them some form of protection. Yes. So even the law requires us to serve our docket or the documentation we have to the defense. So applications are made even before the case goes to court. This shows you how so much is done before a matter goes to court. Yes. So you must make an application to the witness protection, and then you work with them. An application is made to court to have what we call redaction, so that that document goes, but it doesn't have the name of the witnesses, the particulars, and all that. However, threats might come, which we might never get to know. The witness does not tell us. Again, remember, some of the corruption or economic crime cases might also have touched this witness. They must also have pathways. So they also kind of want to, fear. They don't, once I got there, I'll be questioned on the role I played. So the area of witnesses can be very, very challenging, but we soldier on.
Okay. And Anita, just to add on the question you have asked on the challenges, I'd like to highlight one, especially on the high-profile personalities or the high-profile cases. I'd say that one big challenge show how we are trying to overcome the challenge. Personalities involved in this corruption are they have the power, both financial muscle and also their system that they have within either the agency they work for or the government in general. So even as a matter is taken to court before them, they still have a lot of power to put on the issue of bail. They're able to make so many applications. And then also, they're able to also hire very, lawyers, a battalion of lawyers who also complicate and handle the process. And also, we find that they have a political interest in maybe various areas in the country. So they have actually what you'd call their political supporters who sympathize with them. It has been a great challenge, and also even how the media plays a very important role, and they have been playing in informing the public. Sometimes also the perception taken can also be a challenge for the prosecutor and the court. But I'll say two cases which have improved on that front. One is a very recent case that was done in Mombasa, where the High Court made a judgment that other state officers
cannot represent.
That
was a win.
It is a big win because the conflict of interest sometimes is apparent.
Law.
Yes. And make legislation. So in other countries, even corrupt individuals have even influenced the change and amendment of the laws. So that was a very big win. Then the other case is where the access of the public officer in his own office, while his witnesses are likely to be in the same office. We have the case of the Samburu governor, where also the court made a ruling that access to your office can be limited. Yes.
Okay. Now that you even mentioned politicians, there is the very aspect of the citizens' involvement in electing the same leaders. Is there, and I'm just asking this from just nowhere, are you working with, say, the IEBC to ensure that people with questionable backgrounds, especially on integrity, are not on the ballot? Or is it something in the works?
Yes, we have a tripartite interagency forum where we meet all the agencies that are involved somehow in election. The DPP comes in because he prosecutes election and related offences. Again, the DPP, remember, they are supposed to be cleared by the DPP and the investigative agencies, which clearances they have to submit to the IEBC. Thus, those ones who intend to fight for elective posts must seek clearance from the DPP.
Okay.
However, we don't go to electorate.
You don't
tell them don't vote this or don't vote. If the IEBC clears them, they'll be on the ballot box. The best we can do is to we normally have outreach.
Yes.
So the best we can do is to tell the members of public while fighting corruption, look even at the leaders who you choose.
Do you have such programs as ODPP?
Oh, yes, we do. Like we participate during the African Anti-Corruption Day, also the International Anti-Corruption not just the day. In fact, we do a series of activities during that period.
Okay.
So we really go out there to the
Yeah.
common mwananchi,
Yeah.
even telling them about the ODPP, with the same questions we are answering here.
Yeah.
And in any case, this is also outreach.
Yes, this is
Yes.
outreach actually. This is
And
good
at the
outreach.
ODPP, we also have complaints and compliments
Yeah.
division,
Yes.
which accepts and deals with members of public. They can, anything they wish to tell the DPP, they can go through that.
Okay. Okay.
It's in our website.
It's in your website, yes.
Yes.
And a lot of this information is also on your website. There's the annual report. You can find it on the website and just see the statistics we're talking about. And of course, you're most welcome to engage with the ODPP on their various channels, on Facebook, on Twitter, on their website. They have an email. You can call and just find out how to engage with them in case you need any help or clarification. I want us to wind up and maybe just a final submission. You are the public defender. You are our lawyers. You are our nyinyi ndio watetezi wetu. What do you tell the public about the fight against corruption? Because trust is waning. Sometimes you see people getting tired and saying, we are just corrupt, you can't be helped. What is the final submission on that?
On my part, I would say that the office of the DPP and us, the officers who are there, are so committed to fighting corruption.
Yes.
One, we are also members of public.
Yes.
In a way, if it's the country that is not developing,
yes.
we are also affected.
Yes.
If the economy is affected by the corruption, we are also affected. So we are so committed to fighting corruption, and we are not biased towards this side or that side. We stick on the law, and we have to follow the rule of law. Even if it takes some time, we will still do it.
And you're independent.
Yes, because again, we do not want to go to court and be told that you did not have sufficient evidence to bring this person to court.
Yes.
Yes.
So we'll
remember the accused persons also have their rights under the Constitution.
Yes.
Yes.
We're a democratic society as it is. Yes. Terry.
I just say, I just tell Kenyans that the heroes of our country have to change. We must encourage transparency. We must encourage genuineness. And we cannot have corrupt people being the heroes of our society.
Yes.
And like my senior has said, as ODPP and the ODPP leadership is committed to fighting this corruption and being intolerant to it.
To corruption.
Yeah.
Yes. Okay. Thank you very much, ladies, for joining me today. It's been an interesting discussion. At least I have learned something, and I hope the viewers out there have learned that there are alternatives. You can enter into a plea bargain agreement with the system to just as you deal with your corruption case, in case you have one. You can be a witness. You can you also have a right to get to get bail, right? Yeah. And bond. So there are all those things that are available. And of course, I will just echo what Terry has said, that we need to all join together in the fight against corruption. We may have all the systems in place. We can have all the laws like Madam has told us, but then it is also a personal initiative that we have to take to fight corruption. I mean, the impact on corruption, the fight against corruption should be fused with our own integrity system. So it starts from the family and then it goes out. It will be seen what you do within your family setup will definitely be manifested out there. So if we want to win against corruption, we must start from the small things we do at home to what the children are seeing, of course, change our heroes and get active in the fight against corruption. We have the laws, we have the systems. We just need to make this a patriotic fight. I want to end this discussion today and now, but the conversation goes on. There are people still waiting to respond to you. If you have any question, if you need any clarification, I mean, I know I have learned today that even the parliamentary committees, the investigation process has still not started. When you see those things on TV, they are very interesting, but they can form a basis of investigation, right?
Yes.
Yes, but then they are not in the system yet. So when they get into the system, then as Terry has explained, then the whole loop goes until conviction is done or sentencing is done. So thank you very much. I want to wish you a good weekend ahead. And of course, a nice week ahead. Keep engaging with us on Facebook, on Twitter, on email, on call, even on YouTube. And we are grateful for all those who've been following and engaging with us on our platforms. Have a blessed day ahead. Thank you very much.